Senator Romero's not here, but Senator Scher will be here as well as Burton for the votes.
Thank you so much.
And item number 15, Assembly Bill 1044.
Thank you.
Licenses to carry firearms.
Yes. Again, Mr. Chairman and members, AB 1044 is a proposal to simply eliminate the requirement for the Department of Justice to file and store concealed weapons permit applications and to update the required record reproduction format. I have with me today Mark Bain and Randy Rossi from the Attorney General's office, who will be happy to answer any questions you may have.
Thank you. Mr. Rossi?
Very simply, this just eliminates the requirement that we currently have to store and maintain these applications. Some people don't like that at the state level. We have these applications. This is supported by local law enforcement, sheriffs, California Peace Officers Association. Thank you. We'll be happy to answer any questions you may have.
What's the reason for the bill? Say something substantive.
The reason for the bill is to delete the requirement that we...
What's the reason for it? There's a reason. One more reason, no bill, no vote. Tell me why we ought to do it. Why?
The law requires...
I understand.
We don't want to file and store these applications.
Because?
Because they're not accessed. Ability to release this information is more restricted than at the local level. The information is available at the local level. We see no need to put these applications in boxes when there's virtually no accessibility by private citizens, plus almost no request for this information. It's duplicative. The source information is at the local level. They're the keepers of the information. This is a local process. It's not a state process.
So this is
it is a state process now. The law says it is a state process now.
The storing is a state process, but the discretion, the backgrounding of the individuals, et cetera, is a local process. It's not something that we're involved other than just doing a record check of the individual.
You said almost no requests. How many does that mean? Does that mean only 3 or only 800, or what's it mean?
I'm only aware of 3 requests in the last, say, 3 years that I'm personally aware of. I don't believe there's any more.
Yes, sir. In support?
Mr. Chairman, members of the committee, my name is Ed Wardy with the National Rifle Association. I want to thank the Attorney General's office for working with us in the last amendments to help us with the bill. I want to thank someone in the Great Connor for carrying the bill also. Thank you.
Move the bill. Bill's been moved. Is your opposition?
Members of the committee, my name is Jim March. I run the Equal Rights for CCW homepage. I'm an activist committed to the reform of the California CCW weapons permit process. AB 1044 was passed at the first available opportunity after I filed a Public Records Act request for the information the DOJ wants to destroy. There's a few things you need to know about this entire process. First of all, in 1986, California Supreme Court ordered records of CCW issuance, including the complete good cause for issuance, made public. They did so. I'm going to read 2 key one-sentence quotes from that decision. Public inspection of the names of license holders and the reasons the licenses were requested enables the press and the public to ensure that public officials are acting properly in issuing licenses for legitimate reasons. If the information on which the decision to grant can be kept from the public and the press, then there is no method by which the people can ever ascertain whether the law is being fairly and impartially applied. In May of last year, I made a formal complaint on my website that the DOJ had mishandled a process back in 1999 to create a new state standard CCW application form. Up until 99, each CCW application form had the applicant write in why they wanted a permit. Makes perfect sense. Under the 99 forms created by California DOJ, a person dictates to a law enforcement officer what their good cause for issuance is. That is then put into the form in an area of the form subtitled Police Investigators Notes. Local law enforcement has been telling myself, and at times Mr. Chuck Michelle, that they cannot release any good cause data under the Public Records Act request because it is Police Investigators Notes. This was a use of a loophole in the Public Records Act request. AB 1044 allows Cal DOJ to rewrite the CCW application form without public oversight, without public comment. In '99, Cal DOJ wrote the form without public comment when they were required to take public comment. So they want to remove the oversight so that they can do whatever they want with the forms, including overturn a California Supreme Court decision. The other aspect of AB 1044 eliminates public records held at California DOJ Central Headquarters. The most important of those records are the records of denial of permits. The records of denial are key to determining equal protection violations in the handling of the permits. There are an abnormally low number of people of color, minorities, Hispanics, and women who are getting these permits. I would like to see if our abnormally high percentages of them are being denied. The records of denial are consistently not available for some mysterious reason at each local agency. So I would like to go after the central records at DOJ headquarters. Now, DOJ is telling you that those records are sealed. That is not the case. Penal Code 11105 made private genuine criminal records and then set up a method of distributing those records from DOJ out to local law enforcement. Penal Code 1106 said that other records that DOJ is sitting on can be distributed through that same network. The problem is 11106 does not change the nature of those records. It just sets a distribution method. DOJ's position is that the same records, which are public if they came from local law enforcement, are private if they come from DOJ because they're releasable to law enforcement via the private network. But that doesn't change the nature of the records. Once they realize that, they've acted through this bill to eliminate the most controversial of the records for law enforcement. That's why law enforcement still supports the bill, even though the piece has been stripped out that directly affects law enforcement. Do you understand what I'm saying? Right at this moment, local law enforcement should have no opinion on which way the bill's going to act. Now, also in support of, also in opposition to this bill, as of yesterday, the California First Amendment Coalition filed a letter of opposition. If any of you have not seen that letter of opposition, I have copies with me. Okay? You all are aware of that opposition. Okay. One more thing I'll point out. A couple of you are strong supporters of improving the Public Records Act, and I want to thank you. Unfortunately, Mr. Burton's not here to thank. Mr. McPherson, thank you. You have no doubt seen this report published by California First Amendment Coalition in which journalism students analyzed the rate of false rejections of Public Records Act requests. Sheriffs had an 80% wrongful denial rate. Police chiefs had a 64% wrongful denial rate. California DOJ wants to send me chasing around these records among 58 sheriffs and 350 police departments for public records when they are sitting on a central archive of the same material. That's just flat wrong. I ask for your no vote on this bill. Every single element of this bill was designed to foster a cover-up of public records and a cover-up of a continuing violation of equal protection. It doesn't look as nasty as it is. There's only about 5 people in the whole state who could have looked at AB 1044 on first reading and known enough about the history of the bill, the history of CBS versus Block, 1986, to realize what the bill was actually doing. And I am one of those people. If you have any questions, if you'd like to see the CFAC report on the rate of Public Record Act denials, I have a copy of that. Yes.
I'll ask our staff whether when people apply for CCW now, they're required under law to indicate the reason why they ought to get one.
Oh, yeah.
Yes, they do have to state the basis for good cause.
Okay, and is that information public? To be made public? Or is it confidential in some way?
I had thought that it was public, but I think Randy Rossi might be, the Department of Justice might be the Public at the local level, not public at the state level.
Okay. I can show you letters from law
I
enforcement.
didn't ask you, please.
Okay, my apologies.
Okay. So I want to know what's happening at the local level, whether it's being made public or whether, in fact, what this gentleman says, being entered in under the police officer's portion, makes it privileged and therefore it isn't public. If that's true, then the whole thing is really a shuck. We got to find out.
Mr. Chairman, if I can try to shed some light on this. Current California law requires that if I apply for a concealed weapons permit in any county, that if I'm denied, the issuing agency must send me a letter of denial, tell me why I'm denied. So those records open to public record. So
it doesn't answer my question, though.
Well,
it doesn't answer my question. It doesn't ever help with me. You know that by
I understand. I'm just trying to shed some light on the question you had.
I don't think you did.
Okay, well, thank you.
Okay, wish you had. Now listen.
I can add one more thing.
Okay.
The reason for issuance is available, is public information at the local level.
This gentleman has testified that, in fact, it's being entered under the police investigation portion and therefore is held privileged and it's not available.
The information that is held privileged, as I understand it, and maybe Simon can clarify this, is the detailed information that should be held private. Carries large sums of money, 4 a.m., going to Wells Fargo. That's the reason why I need the CCW. We don't have to disclose that information that would put the individual at risk at the local level.
What do you have to disclose? Nothing then.
I
assume that a person wants it for some reason, and the reason is because there's some risk. But you're saying by definition that nothing's disclosed. Right?
The name, and Simon, I believe the reason at the local level, at the general reason, is disclosed. But the details as far as carrying large sums of money and time of the day and what that would put somebody at risk does not have to be disclosed. Otherwise, you put the person at further risk, which is the whole reason why they have the CCW.
Is that determined by the sheriff or the
chief? It is. It's a local process. It's their form. It's their application. That form was developed exactly the way you instructed us to develop the form. It's in the law. The commission and the makeup of the body that was to develop the form is part of law. We follow the law. We take great umbrage with the fact that some of the allegations made by this gentleman, and we welcome a suit to clarify this matter, of which he's tried 3 times.
I've had enough questions and no answers to satisfy me, so I'm not voting for the bill.
I can clarify.
I don't need any more.
No problem.
You shifted the burden, and they haven't shared it, my estimation.
Sir, if you could ask the question one more time, I'll see if I
only asked things 3 times.
Okay, I'm sorry I missed that.
You can't move from first, second? Forget it for me.
Well, there's no other. What I will do, I will make a motion on the bill and then call members as they can come in there at other committees and so forth. And Margette did make the motion. Senator Margette made the motion, so we'll let that stand. Why don't we call the roll on that motion?
McPherson?
Aye.
McPherson, aye. Vasconcellos?
No.
Vasconcellos, no. Burton? Margette? Sure.
And Senator Romero is not here, so there's 3 other members. It's 1-to-1. You need 4 votes.
Thank you. Thank you very much.
Mr. Chavez. Item 21. This is item number 21 on parole placement.